Welcome back to On Just Terms. This is part 2 of our conversation with Stuart Price, CEO and co-founder of CASL. In the last episode, we discussed funders' risk appetites and the qualitative and quantitative criteria funders like Stuart use when making decisions about whether to invest in particular claims. In this episode, we turn to the more contested issues affecting the litigation funding space, including balancing competing and sometimes diverging interests of stakeholders on the plaintiff side of litigation. Stuart, we've been talking a lot about the economics of funding. Funders know when they're pursuing an opportunity that there'll be a lot of scrutiny over the commissions they're proposing to charge. And equally, they know they're going to have to balance a commercially acceptable return with returns to group members. Take us inside a little bit, the thinking that goes on in relation to that delicate balance.
Commission is more of a science than an art. We first set commission at reflective of the risk of the case. So our starting point is our capital must get sufficient return for the risk. Not every case has the same level of risk. Some are more straightforward, settled. Some are not. Duration's an important part, understanding whether you're likely to have many appeals, you're likely to end up in the High Court. Duration's a very important part, but pricing for risk is the fundamental starting point. So once we've priced for risk, as an assessment of what does a case look like, what is the appropriate return for that type of risk, then we've got to test it whether or not that is achievable in the market. Can we go to the law firm? Can we go to the court and expect that return will be achievable? Now, the factors that feed into that are what are the realistic resolution proceeds? What is the cost? What is the duration? All of those are, if you like, the quantitative terms that can be modeled, but you've got to have a reasonable starting point for that to understand what is likely. So we don't work from the big headline number of what the claim might be worth. We work from what is likely to be worth. And then, as I've mentioned before, we look at a contested trial. Let's assume it goes to a contested trial. What is the cost? What is the duration to get there? It's really important. I think this is not as well understood, but courts determine what is fair and reasonable. Not the funder, not the lawyer, not the plaintiff. The court determines on behalf of all the group members what is fair and reasonable. So we can form a view which may be dramatically wrong, and that would be very foolish to do that. And so we need to be very much in tune with what is deemed and supportable as a reasonable rate. From our perspective, we also want to have a reputational overlay. We don't want to have the headline being funder and lawyers are the only ones that benefit from this. So again, at the outset, one of the factors we talked about, red flags, the case may look great, but if the metrics, the actual numbers don't make sense in terms of what is likely to be returned to the group members, then that itself will be a red flag that we would not proceed on.
That's a good segue onto another topic which is related. A lot of ink's been spilt over the triumvirate interests, funder, group member, law firm. The theory is one thing, but could you share a little bit about how, in a practical sense, from your perspective, those interests, which sometimes are aligned, sometimes may not be, how they're balanced in the cut and thrust of the day-to-day of a class action, for example, both when it's working as it should be, but also sometimes when perhaps interests are diverging. What's that look like from a funder's perspective?
I think commercial lawyers would tell you, document in your contract the scenarios, the steps, the processes, if things go wrong. So from a starting point, the litigation funding agreement will specify what happens in the event of a dispute, in the event of a conflict, and that is contracted. That's a starting point. What does that look like? You step back and you say, ultimately, the lawyers are acting in the best interest of the client. And so that will override the interest of the funder every time. The interests do differ from time to time on settlement values, the legal strategies. I put that more into having an intellectual debate on the experiences of the lawyers, the funder, counsel, and actually coming up with the optimum strategy. Sometimes that will end up in a dispute, though, where you can't agree. We have mechanisms in our funding agreements that specify it may be an independent party that determines, or the most senior counsel will determine which view is in the best interest of the client, and the parties are bound by that decision. So there is no undue or avenues for undue influence. It will always have an avenue to take it to the resolution of a dispute with the client's best interest, the group member's best interest front and foremost. I think so I've been in funding a dozen years, business partners being in for 25 plus years. I think we can count on one or two fingers the number of times those issues have arisen.
Yes.
And they're very, very specific circumstances that give rise to them. Ordinarily, the plaintiff team are working very coherently together. We see issues arising from a long time out. So often they're not new issues that arise. The issues that we can see in the horizon, we've worked through, we've tried to mitigate them through legal strategy. And we've been in the trenches together, so we know what the options are. And I think that's why these disputes rarely arise. But if they do arise, there's a very clear mechanism that can be followed, will be followed, and it will be binding on all parties.
It's interesting.
And talking there a bit about the relationship with the plaintiff firm, something I'd be interested in is, see, there's instances now where in the market there's a bit of competition, right? So late last year, we had the High Court overturning the full federal court's decision in Blue Sky, and I think everyone knows that that would have totally changed the class actions ecosystem that we're all operating in. But we still have GCOs in Victoria. What's the competitive dynamic at the moment in the market between the funders on the one hand and the plaintiff firms on the other?
I don't look at funders and law firms as being on two hands. I look at them being on the same hand. So really, fundamentally, that's the point. Litigation funding has become legal finance. I think that's a really important distinction. Funders are now working collaboratively with the law firms. Law firms themselves seek legal finance in order to run the balance sheet, to run actions, be able to bring GCOs. Because of the structure, they're bringing it in their own name, but they need to have financial resources behind them. So I think this is part and parcel of the evolution of this market. Law firms over time will have a war chest that they can build up, like other parts of the world where the law firms have the financial resources capable to bring many different claims on behalf of the firm. Here, we're still in the early days of it. There are a handful of large plaintiff law firms. Those large plaintiff law firms have different practice areas within their businesses. They have different partners with different needs and requirements. And so understanding what a class action does for cash flow, for instance, to distributions to partners, those are one of the steps that they have to go through and evolve their financial management of the firm. So law firms are very much more law firm stroke funders, and that there is far greater grey area there than there's ever been. So I look at it as we're both on the same hand. The GCOs, we're funding GCOs by virtue of the funding to the law firm. We're funding portfolio facilities to law firms, and that's providing them the financial capability and the financial resources that they need to be able to go to the court and advocate as a funder and a law firm that they're able to run the case successfully for the benefit of the plaintiff.
Yeah, that's interesting. So it's not an erosion of your market share. It's really expanding, creating, I think you said, evolution of the ways that funding is working in the market.
And look, I think this is not and should never be seen as a them and us. It really is an approach to the market which says the plaintiff side, if you want to describe it as that, is stronger together with strong financial resources and strong legal resources. And how they're delivered, whether it's through one firm with both of them or two firms, two organizations that bring that in unison, ultimately you want to have strength and stability in the plaintiff firm.
Without mentioning specifics, has the introduction of contingency fees meant that there are law firms that we might not regard as the usual suspects who are now reaching out to the funding market to say, we've got this ability, we'd like that financing? Are we seeing a diversification of our market?
We're certainly seeing new firms appear.
Yep.
The real challenge for them, and this is one of the qualitative factors, looking at the legal resources, looking at the legal team, and making sure that there's the bandwidth, the capability, skills, and experience within those firms to run a class action, a complex class action. So whilst those new firms will participate, from a funder's perspective, they elevate the risk.
I see.
And so you would be backing and funding one of those firms only if they could demonstrate the skills, experience, capability, and bandwidth. I think when you've seen new firms emerge, they're often been firms that have emerged out of the large plaintiff law firms. So boutique litigation firms. Those ones, I think, is a very interesting to identify the differences that they have, because they are class action only firms. And so when I talk about the difficulties of a firm being a funder and different parts of the firm not understanding the cash flow demands and the lockup that exists within class actions, you don't have that existing in these boutique firms, these new firms, because they are one single practice area. So they create opportunities for built for purpose, very specialist firms. And they are attractive because they have all the skills and experience that you would expect in the big firm. We fund both big firms and these boutique firms. But the other firms, the ones that may think this is easy to get involved in, must be streets paved with gold, those ones are not for us.
I see.
We wanted to leave a little bit of time for any kind of final insights or predictions from you, Stuart. What are the top things front of mind for you and CASL kind of at the moment?
So there's a couple of areas that are very much front of mind. One is duration and time and cost. Within that itself is three things, but within that one topic. And they all relate to the complexity of the litigation that we're tackling. Inevitably, and I'll use this as one example, everything is digital now. Emails, text messages, all the documentation is digital. And therefore, discovery, if we approach discovery, plaintiff law firms want everything. Everything happens to be digital. A lot of material to go through. And therefore, security and time taken to go through that process is substantial. So that's a changing nature of litigation. Within those millions of documents, there's still probably only a small number of them that are highly relevant. But we've got to find a way as people within this system and the court to lead us through this system to find an efficient way of dealing with this, because it can't be the solution that we've got to look at every document. Technology is available. Technology gets us so far. But I think that's one of the aspects which I can see within our funded cases, and particularly in the ones that we're looking at the future, is allowing more time cost into our funding, and inevitably that increases expectations on outcomes in order to get the financial metrics right. So absolutely, I think that's one of the key and critical aspects that we're dealing with. I think you touched on GCOs, contingency fees, the evolution of the market. I think that's important. Funders have come and gone in this market. I think that's a reflection of capital is finite. Capital goes to different parts of the world from the same sources, and Australia is a very small part of the world with a very small opportunity relatively. CASL 100% sees the opportunity as Australia and New Zealand. And so for us, we have set up our stall only looking at this market, and that's an important distinction of why we exist in this market. But the evolution of funders and legal finance as opposed to litigation funding, I think that's going to be really interesting to watch. And that's going to be somewhat driven by the changes in New South Wales, whether they adopt contingency fees and other states adopting contingency fees, and whether the federal court adopts those types of approaches. I think we've got a real change happening, and a very interesting change happening, which will create opportunity. And then the last thing I will mention is the inevitable use of artificial intelligence. I think AI as a buzzword, we all get excited by. My earlier points that data only takes you so far. And so as predictive tools, the data set in Australia is particularly small. The data set for cases don't always show the resolutions. If you have 95% of your cases settled before trial, you don't see the cut and thrust of arguments being made in trial, which ordinarily lend itself to AI. So the uses and the efficiencies of AI, both on the plaintiff and defense side and funders side, making sure that we're using it to drive efficiencies. And efficiencies got to drive down cost, got to drive down time, and make the system more efficient. And I think that's probably the three that are front of mind.
So Stuart, you've been incredibly gracious with your time. So let's end with prediction time. And we are going to hold you to these, I should warn you. If we were coming back together in 5 or 10 years' time, if it's 10 years' time, it will be with Mel, because I'll be on a beach somewhere, no doubt. What would you say the funding market looks like in Australia? Is it healthy? Has it changed? What are your observations, just at a high level, of what we look like in a decade?
5-10 years, I might be on the same beach, but I think it's important to see that what's happening now, the merging of law firm and finance. I think that's going to be far less of a hard edge. That's going to be very much merged in 5-10 years. So you will have strong firms with strong financial resources, capable of running a portfolio of cases, having the ability to prosecute them. I think that's absolutely will be the point. So litigation funders may not exist in their own right, but law firms in their own right won't exist either. It will be a hybrid of both. And I think that's where the market is absolutely going to change. And firms that embrace that now, you've got to have the legislation that allows some forms of law firm ownership. They've been tried elsewhere in the world, and there's some models to look at. There's going to be opportunities here through different jurisdictions that embrace some of these, try some of these, and some will be successful and some won't be successful. But I think it's having the willingness to be flexible. I think all of us need to be flexible because the world is changing rapidly. Be able to adapt, be able to change, and really see opportunity rather than fear.
Those have been some incredible insights, Stuart. We're so grateful for them. Thank you for being a guest on our podcast and being so gracious with your time. And We hope to connect in 5 or 10 years to test you on those predictions, but thank you for joining us.
Thank you.
Thank you. Thanks for joining us for the second instalment of our conversation with Stuart. We've gained some fascinating insights into what happens when the interests of stakeholders, lead plaintiffs, their lawyers, funders and counsel diverge in the context of class action settlement negotiations. Stuart was also reflecting on the evolution of litigation funding and indeed the future of, as Stuart puts it, litigation financing, and sees that there is a future for both funders and plaintiff firms. The litigation funding market is dynamic and growing, with clear implications for corporate Australia. All players in the market will need to be flexible in the face of these changes. We will continue to closely monitor developments in this space and look forward to further discussions with you on emerging trends and risks that may arise.